Before I get started, I have to start with a disclaimer. I am a defense attorney. Never argued for damages in my life. I've never persecuted people before. So obviously we're going to have a bias in this. The other thing is everything that we're going to talk about, 90% of it really goes from voir dire, opening, direct, cross, to closing. So don't think of this as exclusively closing. The things we're going to talk about are going to apply throughout the entire trial. And last, for those of you who've seen The Big Lebowski, that's just like your opinion, man. There's a joke in The Simpsons, I'm going to butcher it, but Homer is creating an alter ego of, I think it's Max Powers. And Homer says to Marge, he says, there's 3 ways to do things. The right way, the wrong way, and the Max Powers way. And Marge says, well, isn't that kind of like the wrong way? And he says, yes, but only faster. So I'm going to give you the Max Powers, Vinnie Rivera way of how to do a closing argument. Again, this is, take from it what you can benefit from. There's absolutely going to be other attorneys who disagree with some of my points, some more strongly than others, but that's why this is called the practice of law and not the science. Closing arguments. Mindset, techniques, and execution. When I talk about mindset, I'm talking about the perspective that we're going to approach our closing arguments from the story, from ourselves, and from the jury. When I talk about techniques, we're going to be talking about how we're going to put this all together and create these arguments. And then execution is really going to be putting all that together, combining the mindset with the techniques and organizing that into a coherent closing argument. Mindset. So let's first start with the story. And it's really more the perspective of the story. What is the dominant emotion in your story? If you can think of one emotional reason why your side should win, what is it? We make decisions, we are emotional creatures. Think about anything out there, abortion, Trump. We all have opinions on it. And whatever our opinion is, it started in our heart. It started emotionally. Then we come back later, we try to apply logic to make it sound like we're making a logical decision. Have you ever had a friend who was dating someone that you hated? Did you ever go and talk to him? You made the best logical argument you could ever make about why they should not marry that person or break up with them. And they just go, yeah, but I love them. Well, they're making an emotional decision. They're not making a logical decision. That's why your logical arguments didn't go anywhere with them. And so I think we need to approach our closing arguments from the emotion. We're going to use the emotions to lead the horse to water. And then obviously drinking is going to be applying the law and coming to the verdict that you want them to come to. What is the mindset of the jury? I want to talk about jury empathy. We are all selfish no matter what, and it keeps going through trial. We're in trial, oh boo-hoo, I haven't slept in 2 weeks preparing for trial. Oh my God, there's so much pressure on me, me. What's the jury going through up there? Most of these folks have been jerked out of their lives. They're stressed out, and their stress can come from a lot of factors. Stress can come from, obviously, the gravity of, I'm about to make a decision that's going to affect someone's life. They can be stressed out because maybe they don't understand the law. Maybe they're stressed out because of things at home. Maybe they're stressed out from information overload. What are they perceiving? So this stress is going on in the background, and it's affecting their perceptions. It's affecting what they're hearing. It's affecting what they're remembering. Their knowledge of the law is going to affect how they apply that to the case. And so we need to go through this with the mindset of what is the jury actually hearing, seeing, smelling, tasting, all of their senses. We know, and it's pretty much undisputed, that during oral presentations, People only retain a small fraction of what they're being told. But again, we expect jurors to just remember 100% of what's going on at trial. And that's not the case. That's why we use some of the techniques that we use to make them more memorable and to repeat things. And so they won't forget. Because if you mention it once, they've got one chance to forget it. If you mention it 10 times, well, now they've got to forget it 10 times. And then, of course, what is your mindset? Now, I really want to combine these two things. So, when we talk about your mindset, you need to be on the offensive the entire time. Do not spend your closing responding to the other side. This is your moment. This is your case. There is only one side of this case. It's your side. I also want you to become the foreperson. We're going to go through this one a lot. It's going to be recurring throughout this presentation. But the idea is pretend like you're not a lawyer. Pretend like you're a juror during your closing argument. Pretend like you are trying to figure this mess out with them. And we'll talk about strategies on how you can do that. But remove yourself from being a lawyer, jump in the jury box with them, and help them figure out this case. And of course, you're going to guide them through the law. You're the shepherd through the valley of darkness. We got all this information. What's important? I don't know. I've been sitting here for 3 days listening to all this testimony. What's important? The judge just spent 15 minutes reading me jury instructions. I don't even understand what those mean. We know there's only a handful of facts and a handful of things in the law that actually matter. And so it's your job to guide them through this ocean of law, this ocean of facts, to the points that you want to make. Techniques. Hooks, becoming the foreperson, rebuttal, the law, and objections. We'll start with hooks. We're working on all these throughout the week, so none of these should be new to you. Trilogies, storytelling, news headlines, quotes. But at the end of the day, they need to be retainable, recallable, and retellable. Trilogies. Battered, bruised, and bleeding. When you use a trilogy, it's important to follow up with an explanation. Battered, bruised, and bleeding. Ben Long laid on the cold pavement of the parking lot. Battered from punch after punch from Mr. Stites. Bruised from the relentless beating he received. And bleeding out of his skull, which will turn into a concussion. Storytelling. Obviously, we spent a whole day just on storytelling. One of the key points for storytelling is moments of decision, or choices. But the reverse of that's also true. A choice not to do something. So, for example, in the Liquor Commission, the city made a big deal about Walter Watkins leaning on the pole, stumbling down the street, yada yada. But that only matters if Dan Jones saw that stuff. So what did the Liquor Commission ever do to prove, or at least imply, that Dan Jones saw that? Did they ask him if he saw him walking down the street? Did the commission stand at the counter and look through the window to see if there's even a line of sight down there? So choices, what people don't do, is just as important as what people do. And juries really bite on that. Because I think they have more of a tendency to side with you if they feel like people have a conscious decision or chance to do something, but they just don't do it. And of course, organize persuasively. I can't think of an example where the beginning of the story is the most interesting part. How many movies have we seen where they start at some point in the middle or at the end of the story, and then they do a flashback? Very first episode of Breaking Bad. It opens up, this guy's driving an RV, he's wearing a gas mask, he's swerving all over the road out in the desert, camera pans to the back, there's two lifeless bodies kind of swishing around in this liquid. Boom, the RV crashes off the road. The guy gets out of the driver's seat, he's wearing his gas mask, he's got a shirt, I think he's in his underwear. He's got a .44 Magnum, and you can hear the sirens coming around the way. Boom, cut to credits. Wow, what's happening? I'm sucked in. Then after the credits, then they started this birthday party, which is boring. They organized that storytelling persuasively. They started at what I would say is the emotional epicenter of that individual episode. And don't be married to stories from your case. You can use stories from anywhere. Wisdom tales, fables, proverbs, parables, TV shows, movies. I had a friend who set up the South Park Chewbacca defense. He introduced the South Park episode through speaking, and then he turned around and said, if the Wookiee lives on Endor, you must acquit. I don't think I could pull that off, but he did. News headline. This is similar to some of the exercises we've done, and I really like this one to help with writer's block. If you're really stuck and don't know what to do, try this one. And the idea is that your juror is sitting there at the breakfast table before reporting to jury duty. And they're reading the newspaper, and you get to write the story that they read. You get to write the headline. So in 10 words or less, what does that headline say about your case? You can also turn those into questions. So in other words, you can take the headline, which might say something like, overworked clerk mistakenly sells to drunk person. You could turn that into a question. Say, some of you may be asking, why would someone sell to someone who smells like alcohol? Some of you might be asking, what is the pressure like of having to run an entire liquor store by yourself during a busy Saturday night? Quotes. Quotes from the case. Are there any good quotes in the Ramirez case? It doesn't have to be from the case. It can be historical. It can be fictional. Again, from movies, books, songs. A particular song lyric that you think really drives your case theory home, use it. Becoming the foreperson. Your job here is to guide them through the law. You're narrowing the issues. Taking all this facts, some of it matters, some of it doesn't. They've got all this law, some of it matters, some of it doesn't. You are narrowing their focus, you're narrowing the issues into what is important. You're going to become the reasonable person. And when I say this, and part of what this means is don't take outlandish positions. Try and imagine, what would your parents say? What would your best friends say? What is a reasonable person going to be saying about this case? And if your argument is something that you don't think somebody back there might say, you probably shouldn't say it either. pose questions versus answers. Back to need a liquor commission. We could say the investigator failed by not standing behind the counter and looking out the door to see whether or not Dan Jones could see Walter Watkins. The investigator failed by not even asking him. You could do that. Or you could say, whose job is it to prove that Dan Jones could even see out that window? What steps did the investigators take to even answer that question for us? And it's a slight difference, but it's the difference between being told versus leading you to water and then drinking. And when questions make people create their own answers, and everyone is more receptive to their own answers than they are to being told anything, even though I'm telling you this now. Do you think people are more receptive to their own answers than being told? Another technique we're going to use for becoming a foreperson: get rid of I, get rid of you. I'm the lawyer, you're the jury. No, we're all in this together. How do we decide blah, blah, blah? Let's talk about blah, blah, blah. And by phrasing it like that, you're making it feel like more of a discussion. Likewise, when you're posing questions, what do you think? No. Well, what do we think Dan Jones could see from the clerks, or from behind the counter? How can we figure out that? My client. I will jump out of a window if I ever hear you guys saying my client. Your client has a name. Just say it. Do you think anyone back in the jury room is going to be saying the client? No. They'll be saying Mr. So-and-so, blah, blah, blah. Anytime you have that urge to say my client, just say their name. And what all this is doing is this idea of arming your allies. You know, there's a strong school of thought, which I kind of agree with, says the jury's already made up their mind. Or it's kind of like politics, swaying an election. We've got people who are going to agree with one thing, people are going to disagree, and then there's some people in the middle. And so when I talk about arming our allies, you're giving them the ammo they need to push your point back in the jury room. You're preempting the arguments that the other side is going to make. And ultimately, you're arming them to sway those people in the middle and hopefully on the other side and against you. Rebuttal. True or false? The defense does not get a rebuttal. False. You make your own rebuttal. You put a section in your outline, leave it blank, and as the other side's going, you just take some notes about what their arguments are. This allows you to respond on your terms. We just talked about mindset and about how you need to be on the offensive. You need to be asserting your case theory the entire time. You need to be asserting your arguments. Don't be on your heels responding. But by creating a separate rebuttal section, you're making a safe space to do that. And you don't look like you're on your heels. You don't look like you're afraid, like you're spending your entire closing responding to them. Setting fires. This works a little better for defense than it does for plaintiff. But essentially what that means is you pose slam dunk, unanswerable questions. And let's see if the plaintiff can answer that when they get back up here. Let's see if the plaintiff can tell us why Detective Beer didn't think it was necessary to take photos from behind the clerks. Let's see if we can explain why Detective Beer didn't even ask Dan Jones blah, blah, blah. Now, when it comes to setting fires, I can try and do my best. But I can't do it better than him. Johnny Cochran is truly the greatest of all times. Now, I'm about to show you a clip of the greatest fire. This is a forest fire. This one clip I'm about to show you probably got him the acquittal in this case. And let me set it up for a little bit. At this point in the OJ trial, it's been about 9 months. It's been an absolute media circus. Closing arguments are a couple days long. I think Johnny Cochran's was about 6 hours long. Yes, I've listened to it, and it is wild. And if you ever have 6 hours with nothing better to do, I would highly recommend you check it out. So the clip I'm about to show you, it's the very end, maybe last 45 minutes of his closing argument. And he's gonna set the fire of all fires. So I'm just gonna let him do it for you.
Now, as it comes time for me to conclude my remarks, I may never have an opportunity again to speak to you, certainly not in this setting, maybe when the case is over. As you've been told many, many times, there's a very heavy burden placed upon the people, and for good reason. Prove this case beyond a reasonable doubt. As such, it is Ms. Clark's duty to answer for you, as best she can, any legitimate questions arising from the evidence, which we believe casts doubt upon Mr. Simpson's guilt. There may be 1,000 such questions in a case like this, which will be put to her, but we intend no such exercise. I do think, after careful deliberation, that it might be fair to suggest 15 questions, just 15 questions, which literally hang in the air in this courtroom at this moment. And as the time approaches for you to decide this case, for us to hand the baton to you. I offer these questions now as a most important challenge to the prosecution. The prosecution which claims that it's met its burden in this case. If that burden has in fact been met, you will be given logical, sensible, credible, satisfying answers to each of these 15 questions. If the questions are overwhelming and unanswerable, they will be ignored, or you'll be told that the prosecution has no obligation to answer questions. If you're given anything less than a complete, sensible, and satisfactory response, satisfying you beyond a reasonable doubt to these 15 questions, you'll quickly realize that the case really is transparent, and you'll think about the scenario that I just went through for you, and that the term smoke and mirrors that you heard about have applied to the defense. We prove real, hard things for you, things that you can see, things you can take back in that jury room. And accordingly, you have to find Mr. Simpson not guilty. When I concluded, for Ms. Clark's convenience, should she decide to deal with these very troublesome questions, I'm going to leave a written list of these questions here when I conclude. Let me go over these 15 questions with you just briefly. 1. Why, they're on the monitor, did the blood show up on the sock almost 2 months after a careful search for evidence? And why, as demonstrated by Dr. Lee and Professor McDonald, was the blood applied when there was no foot in it? Think that's a fair question? In this case, let's see if she can answer that question.
Okay. Like I said, you spent 6 hours watching it yourself. Okay, so I want to unpack that for a second. There's a lot of things I like about that. I think first of all, he starts off with a headline. He tells them, hey, this is what I'm going to do. I'm setting fires. He spends a couple minutes teasing and alluding to the questions. I think he says these questions about 5, maybe even 6 times. So by the time he gets to the questions, there's been a pretty powerful windup, and everyone's kind of on the edge of their seat, like, what are they? What are you going to tell us? I think he excellently threads the needle on reasonable doubt. As defense counsel, we can never say, this is reasonable doubt. But he very, very strongly suggests that if they can't answer these 15 questions, that's reasonable doubt. And of course, it's an excellent summary of the case. We've got 9 months worth of information. We've got 6 hours worth of closing. And he puts a nice little bow on it. That whole clip is only about 15 minutes. And of course, as I keep mentioning, he poses questions. He could have said, why did the blood on the sock, why did the blood show up on the sock almost 2 months after a careful search for evidence? Why, as demonstrated by Dr. Lee, blah, blah, the blood was applied when there was no foot in it? Do you think that's more powerful than if he would have came out and said, the blood was applied when there was no foot in it because blah, blah, blah? But by posing the questions, again, he's leading them to water, and they really have no choice but to drink. They really have no choice but to answer these questions in a way that's favorable to them. And of course, my personal favorite, just being a smartass, I just love, I'm going to leave a list of these questions up here if he chooses to answer it. Oh my. I'll buy you lunch if anyone ever does that one. Techniques, the law. I put this separately. My opinion is that the majority of your closing should not be spent on the law. And this is one of those things where a lot of attorneys are going to disagree with me on. But again, my rationale here is we're making our decisions emotionally, not logically. The law is boring. It may be unintelligible to certain jurors, but we can all understand anger. We can understand recklessness. We can understand rage. So use the optimal amount. You know, what is the optimal amount of spicy? Right? From 0 to 100. Probably not 100, and it's definitely not 0. So what is the optimal amount of preparing for your ITAP presentations? Right? You could spend every single second between now and your trials on Saturday. That's probably too much. Or you could blow it off and do 0. So what is the optimal amount? And it's obviously more art than science. Keep it simple and to the point. Prosecutors here are going to want to stab me for this one. Don't argue uncontested facts. If no one's arguing about jurisdiction, no one's arguing about ID, if no one's arguing about the date, don't waste time on those topics. The jurors only have so much attention. And if you want to burn it on elements that no one's arguing about, be my guest, because that's your time, not mine. We use jury instructions. There will be parts of the jury instructions that are relevant to you. There's going to be parts that you want the jury to use. Identify those as succinctly as possible. You can use an Elmo, you can use a blow up, or you might even just repeat them. And of course, burdens of proof. Objections. These objections are pretty much only going to find in closing arguments. Burden shifting. If you're a defense, anytime the plaintiff or prosecution says the defense didn't, objection, burden shifting. Anytime that anything is suggested that the defense could have, would have, or should have done, objection, burden shifting. Misstating the law. You've got to know the law. You've got to know your jury instructions. If they get up and they're misquoting something from the jury instructions, you need to know that. You need to call that out. Misstating evidence. Witness so-and-so said blah, blah, blah. No, that's not quite what they said. Objection, misstating the evidence, may we approach. And the golden rule. Anyone know what the golden rule is? The golden rule is, imagine how you would feel if you were shot in the back by police. Imagine how you would feel if you were overworked running a liquor store and someone came in. It's just an easy little fix. Change you to someone or to the defendant. What do you do when you object in closing? You move for a mistrial, which you probably need to do. You're probably not going to get it, but for the record, and certainly when the stakes are higher, you're in a death penalty case, every objection needs to be followed by a motion for mistrial. The other thing you can do is ask for a limiting instruction. Objection, burden shifting. Your Honor, we request the court to give a limiting instruction on the burden of proof. Boom, and then the judge says, the court would remind the jury that the defendant is under no obligation to produce any evidence here. Man, you just got the judge to back you up, not even sustain your objection. He backed it up. He doubled down on it. Summary. Hooks. Become the foreperson. Be the reasonable person. Arm your allies. Pose questions. Don't you dare say my client. We, us, let's, how do we figure this out? Pretend you are a juror as much as you can. Rebuttal. You're responding on your terms at a designated place of your choosing. You are not letting the other side dictate how you're going to run your closing argument. The law, use the optimal amount in your objections. So now let's put it together in execution. And this is intended to be kind of just like a checklist, a how-to for you guys. Creating a hook, creating chapters, and then at the end, we're going to put it all together into a coherent story, narrative, argument. So let's create a hook. First, we identify what is the dominant emotion. Why? Why should your side win from the heart, not from the head? Why do you feel? Why should the jury feel like you win? What is the emotional epicenter of the story? What is the most interesting? I should say interesting. Where does that emotion come out in the story? There's got to be one point where it peaks. Identify that. Once you've identified that, go back to our techniques. Use trilogy, storytelling, news headline, quotes from trial, historical quotes. And you need to create a hook that is retainable, recallable, and retellable. Creating chapters. What I suggest to everyone, put a bunch of blank pages at the end of your trial notebook. And it's a 1 page per argument, right at the top, whatever the argument is. Bad eyewitness ID. So you've got all these in the back of your trial notebook. And as the trial progresses, something may pop up. Maybe a quote from a witness, maybe an idea in your head. You just flip back, just jot it down on that page. And by the time you get to your closing, you've got all your arguments already done for you. Organize later. That's another reason we keep it on separate sheets of paper. Because then at the end, then you can worry about organizing. And I think if you try to organize it up front, you're going to hit writer's block real bad. Oh, should I do this one first? Should I do that one? You're wasting time. Don't worry about it. Get it all out there. The same thing I think is true also for writing. I have this problem when I write, and it's taken me years to realize it. I don't like editing. I want that first sentence to be perfect, and I'll sit there and toil for 20, 30 minutes to write one sentence. And it's only after years and years that I realized the best thing to do is just write everything, put it to the side, come back later, reorganize it, reiterate it the way you want. Organize later, let's get them all out there. Factual arguments, legal arguments, damage arguments, and rebuttal arguments. So on that one-page piece of paper, you got your argument at the top. Bad eyewitness ID. Create a new hook around that argument, or link it back to your main hook. What quotes from trial support this argument? Plan on transitions. Clean headlines coming in, clean hooks coming in, and clean exit. On exit, it can be as simple as this. Blah, 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 blah. Now let's talk about the ID in this case. Let's talk about what questions we have about that ID. Or you stop, you pause, maybe use a little bit of movement, go look at your notes, blah, blah, blah. Come back and jump into it. Obviously, plowing directly from one argument to the next is bad for a number of reasons. Not the least of which is if you lost their attention and they were bored toward the end of that one, you're not going to magically regain that attention if you just plow through it. But if you have a good transition, pause, you may be able to recapture their attention. What visual aids and exhibits are you going to use to support this argument? You're going to be in what objections do you anticipate? Are you planning on pushing the envelope here with your description of the law? Be prepared. The foreperson rebuttal. What that means, I usually reserve a little chapter toward the end of the chapter, I guess I should say section at the end of the chapter. Again, you're being the reasonable person. You know what the average person is going to probably respond with. So, talking about bad eyewitness ID, blah 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 blah. You get to the end of your of that chapter. Say, now, some of you might be thinking, well, the prosecution has no burden to prove the height of this guy, and just because the witness was mistaken about the height. Who cares? The prosecution doesn't have to prove that. That's not an element of the crime. But let's not forget that tells us how well they were proceeding. The fact that they were wrong about the height of the person, do you think that means that they might be wrong about anything else with the identification? It's this idea of arming the jurors. You're not telling them to go back there and say that. But the jurors who agree with you are going to be hearing those arguments. And then when they hear those arguments behind closed doors, now you've armed your allies to use those arguments. And of course, mindset. Is this chapter oriented around the dominant emotion of the story? Is it empathetic to the jury, to what they're hearing, seeing, remembering, their understanding of the law? And of course, are you on the offensive the whole time here? Are you being the foreperson? Legal arguments. KISS. Keep it simple. Thank you. Now, why separate chapters? I tend to keep the factual arguments factual. I try to keep the law out of those as much as I can. I use separate chapters because I can cue them up and you can give them a headline. Okay, well, let's talk about what the law says now. So they know, okay, all right, here we go. We're going for the law. And also, it gives you the chance to reiterate the arguments you've been making. So bad eyewitness ID, blah, 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 you make all your arguments, you get to the legal arguments, you know? And we talk about, well, you know, the law gives us some factors to consider with eyewitness ID. So let's go through those factors. Blah, 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 blah. Boom. But you've already addressed that. So again, you're just getting another chance to double down on some of the stronger points that you have already made. Again, you're arming your allies. You're equipping the other jurors with the arguments they need to persuade. And of course, rebuttal arguments. You have an idea of what the other side is going to argue. Damage arguments from a criminal defense attorney who has never once in his life argued for damages. Again, keep it simple. You got basically economic damages. That's going to be things like medical bills, lost wages, non-economic damages. That's going to be stuff like punitive damages, pain and suffering, and anticipate what the rebuttal arguments are going to be. We know we're talking about money, so somebody back there is going to say, do they really need that much? Be prepared for that. You know, someone may say, do they really need, you know, a new wheelchair ramp for their house? You know, oh, I think that's ridiculous. Well, be prepared to deal with that. Rebuttal. This is a section in your outline that's blank. This is where you're listening to the other side and you're putting down the arguments on the fly for what they're going to say. It's important here, again, to have a headline. You know, so you might, what I usually say is something to the effect of, you know, burden of proof, blah, blah, blah. You know, so the prosecutor is going to get a chance to come back up here. They're going to get one last chance to talk to you. And I'm not going to get a chance to respond to them. So I want to take this opportunity to respond to some of the things that they've said. Boom, 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 boom. Set some fires. My final organization view looks like this. Hook, chapters. So now that we've done all that, now you can organize your chapters. Go with the strongest one first. And there's psychology behind this. If you start with your weakest argument first, you might go, and you build up to a stronger argument, that is really going to poison the well as you go up the scale. Whereas if you start with a really strong argument, they're going to be much more accepting of the weaker argument down the line. And attention. Chances are, attention-wise, they're going to get bored farther down here. Their attention is going to be the highest at the beginning. So start strong, because they're going to be paying the most attention. First and last words out of my mouth are always the same thing. It's always my hook. Start with the hook, go through the chapters, talk about the law, rebuttal, do a quick recap, and then the ask. And the ask is just that. What verdict do you want them to come to? I like to take the jury instruction and say, you know, sign here for not guilty. If you have a little trilogy, you know, blah, blah, blah. Sign here for not guilty. We don't know what Dan Jones saw out the window. Sign here for not liable. They'd end with the hook. Summary of execution, create the hook. Create the chapters, and organize. Face it, not guilty, that's how I stay guilty.